We have a house.
Sorry, good evening. Apologies for the delay in start. I'll let you take over.
In the Glen Clover.
Hopefully everybody will be able to hear me. If we need to use the microphone at some stage, let us know and we'll adjust. We will get started. Thank you very much for your patience. Obviously we have one member of the panel who is delayed in traffic, who will make a grand entrance at the appropriate moment, and we will, hopefully before he's due to speak.
Maybe he was kidnapped.
Maybe he needs a lawyer.
We have some here.
Good story.
So thank you for coming out in such force tonight. We're honored here to have such a distinguished panel here to hear from on various aspects of whistleblowing. So let me just say a few words from the perspective of Amnesty International, just in terms of how important this issue is and how important it is to examine the different facets of the kinds of cases that we'll hear a little bit about tonight. Obviously, Amnesty has worked very recently on cases like the case of Edward Snowden, about which you'll hear, Chelsea Manning, and other whistleblowing cases. What I think is really critical for us to keep in mind is the fact that the act of collecting this information, of turning it over to the public, to the world at large, is inherently an act of defiance, an act of an expression, we think, of the human right to free expression. It comes with the tension that these kinds of acts are often considered illegal, and there may indeed be some very technical violations of things like trespass laws or other things. So what I think we are trying to look for is the proper balance between all of the competing interests, bearing in mind the very, very weighty interest that the right to freedom of expression has. And that's why we have different panelists today speaking on different cases and from different perspectives. I'll introduce briefly each of the panelists in turn, just so you know who they are, but I'll give a longer introduction before each of them begins to speak. So we will hear from Peter Hunem, a British investigative journalist. We'll hear from Avner Feldman, who has represented Mordecai Vanunu over the years. From Kathleen McClellan, with the Government Accountability Project in Washington, working specifically on national security and human rights. From Nancy Hollander, a distinguished lawyer, now the lead counsel on appeal to in the case of Chelsea Manning. Nicholas Mercer, who is, as I understand it, a clergyman, a solicitor, and a former member of the military, who will speak to us on various aspects of whistleblowing and whistleblowing in cases of torture, with some specific reference to Iraq. And coming up the aisle, Frank LaRue, the UN Special Rapporteur on the right to freedom of expression. We are once again very honored to have such a distinguished panel. I think in the interest of letting Frank settle in, let me introduce Peter before having him speak, and we will come to Frank in a second. So Peter, as I said, is an investigative journalist. He's worked for the Sunday Times, the Mirror, the London Evening Standard, BBC Television, published numerous books, and among other things has been involved from very early days in the case of Mordecai Vanunu.
Good evening. I'm probably in a difficult position tonight because I noticed that if in the lineup we've got 5 people who are more sort of focused on the law and come from that area, whereas I'm the only journalist on the panel. So I'm here to be taken a pot shot at. And if you've got any questions afterwards particularly about the Vanunu affair, because I'm not going to be able to go into it in detail tonight, please ask them at the end or grab me afterwards. Whistleblowers are a big issue, but for every whistleblower, usually there has to be a whistleblowee, someone like me, an investigative journalist that they could actually talk to. Sometimes they might go to a member of Parliament, they might go to some other agency, but probably in the end, the story will end up with a major newspaper or a major broadcasting organisation. And so it places a very interesting responsibility on us journalists, and I want to cover some of that issue tonight. The Sunday Times first got involved with Vanunu in 1986 when I was asked to go to Australia where he was living to debrief him. We heard that he knew a lot about Israel's nuclear weapons program, and eventually the story was published, but it had, of course, catastrophic consequences because he ended up being kidnapped and being in jail for 18 years. I'll talk a little bit about that more later, but I just want to make a point, and that is that the Sunday Times doesn't have a great track record with whistleblowers. If you think that David Kelly was also a source of information to the Sunday Times, and he ended up dead at the end of it. But you've obviously got to acknowledge that other newspapers haven't got good records too. The Guardian, I don't think they could be too proud, in my view, of what happened to Edward Snowden. He's now holed up in Moscow. He may never be able to get out of Russia. His life is on hold. That's a sad situation. And some people might think that Julian Assange isn't a daily place stuck in the Ecuadorian embassy. And so I want you to understand that dealing with whistleblowers, however hard you try, frequently ends with serious problems. But we need them. We need whistleblowers because we need to expose serious failures of governance, which are of vital public interest. I'm talking tonight about really serious issues. I'm not interested in blowing the whistle on footballers or footballers' wives or things like that. That is not my area. We're talking about things that really matter, that change the way we're governed. And sometimes it is absolutely essential for someone to tell us what's going on, even if it's illegal. Indeed, I think I would argue that there is a moral duty on someone to blow the whistle if it's as serious as some of the issues that we're talking about tonight have got to be brought to light. So the whistleblower approaches someone like me, and they hope that I and my newspaper will know what to do. Well, they shouldn't be so confident because it doesn't matter how much resources you've got and how much experience you've got. Every whistleblowing case is different. Every person who is a whistleblower is different. And you just don't know what's going to befall them. The key issue that we as journalists have to address is that we can't walk away from them. We have a responsibility not only to make sure that their story appears prominently, and that is a problem sometimes. The newspaper might not be willing to give it the due prominence that will actually have the effect of making changes. That's one of the responsibilities. Another is that we've got to get the story right, which means that we have to find out if the whistleblower is telling the truth, whether they are bona fide. For example, in the case of Vanunu, we had to find out whether or not he really did work inside the nuclear weapons plant in Israel, which took a while to suss out. And we have to provide as much protection as we can to them. Of course, that's the subject tonight. If you take someone, let me just give you one little example. There's a lady called Kathy Gunn, some of you may remember about, a few years ago. She got arrested after blowing the whistle on plans within GCHQ to bug UN officials who were discussing Iraq. And she made this point, and I think it's worth reading some of it out. What has to be understood, she said, is that most whistleblowers are not natural activists. This one certainly wasn't, meaning her. We usually work in anonymous jobs far from the spotlight. We're not campaigners or journalists or wannabe celebrities craving a platform. Our conscience tells us we have to reveal what we know. We do that, we blow the whistle, and overnight the whole media circus descends on us. I'm writing biographically because that's what hit me. It hit me so powerfully, and it was how I felt alone. And I think she obviously had second thoughts afterwards on whether it was wise of her to go public. Interestingly, she was prosecuted and her case came to court, but within half an hour the case was stopped because the government wasn't prepared to go ahead with it. They were frightened, I think, that they would have to reveal too much to the court, and so she got released. oh, that had happened to poor old Mordecai Vanunu, who had all sorts of reservations, and we had lots of discussions about what he should be doing. And like Cathy Gunn, he was unprepared. Who can be to suddenly becoming potentially in the spotlight? Just to remind you, not only did he spend 18 years in prison, but 11 and a half years of those were in solitary confinement, and it, for a time, had a serious effect on his mental state. As I say, he's one of the worst victims of this, but he didn't lose his life. And I want to tell you something about that. Mordecai made a huge mistake. I don't want to ignore one crucial issue about it, and that was, although we were making huge efforts to protect him, he met a woman one day when he was on his own in London, and he thought she was worth dating. They went out a couple of times. She suggested they should go to Rome. She was a Mossad agent, of course, called Cindy, and in Rome he was grabbed, he was knocked to the ground, he was drugged, and he was smuggled onto a boat. And that boat took 5 or 6 days to sail back to Israel. Now, there's quite a significant thing about that. It took 5 or 6 days, although it could have only taken 3 if they wanted to steam quickly. In the meantime, while this boat was on its long and dawdling journey, we had to make a decision on whether or not to publish his story. At that stage, it hadn't been published. And on the Sunday, during the journey, we published the story, and we photographed him, we named him. He became a public figure. I have a view that if we hadn't published the story, or if we had not named him and made his identity public, then there is a possibility he might not have got back to Israel. And we might never know what had happened to him. You know, the reality is that we could never have protected him from a Mossad agent hit team like was assembled against us. So I make this point. You might think that it's better sometimes for whistleblowers to be anonymous, but I think sometimes that is equally dangerous. I refer you, of course, to the story that's very current at the moment to do with Qatar and the FIFA revelations, millions of emails that have come from some mole in FIFA that the Sunday Times has not named. I think there are 2 consequences of that. One is that he or she is possibly more vulnerable not being known who it is. Secondly, there have been all sorts of allegations, notably from Sepp Blatter, the president of FIFA, that the Sunday Times was being racist in publishing this, whereas if the mole turned out to be a Qatari mole, it would be very difficult for them to do that. Not knowing the motive of the leak is really quite an important thing. Time is not on my side, but I've thought a lot about how you protect whistleblowers, and I don't think the press is competent to do it. But I do think that we have to think how in other ways and how we could do it. We're going to hear tonight, I think, about how the law could be improved to protect whistleblowers, but the law isn't the answer anyway, because if you get kidnapped and thrown into jail in somewhere like Israel, it's not a great deal of help. So actually, a few years ago, I made a proposal to the Roundtree Trust that they should help set up a thing called Whistleblowers Anonymous. And in the last minute that's allowed me, I'd just like to give you an idea what the idea was. The idea was that a very well-financed and organisation with a very prominent and respected board of trustees should set up to actually, which would actually allow whistleblowers to go to the organisation, to Whistleblowers Anonymous, which would actually investigate in great depth the information and publish the information without identifying the source. Because the organisation was well respected and well financed and did a job that was provably in the public interest, it might be possible in those circumstances for the whistleblower to just fade out of sight. Of course, it doesn't stop them being kidnapped and so on. But it makes life a little bit easier. Things like that I wanted to throw in into the discussion, because Amnesty International is getting more involved in this sort of issue, and it's something that Amnesty itself might want to consider. It would be a very ambitious idea, but Amnesty International was a very ambitious idea when it began. Thank you.
Thank you very much. We're going to turn now to my left here, to Frank LaRue, the UN Special Rapporteur on the promotion and protection of the right to freedom of opinion and expression, a post he's held since 2008. Many of us will know him for the 30 years and more that he's worked in human rights, including as the founder of the Center for Legal Action of Human Rights, CALDE, in Guatemala, and also in Washington, D.C. His work on the first genocide case against the military dictatorship in Guatemala, and his more recent work as part of the Ministry of Foreign Affairs of Guatemala as a human rights advisor, as well as a presidential commissioner for human rights in Guatemala, among many other prestigious posts.
Thank you. Thank you very much, and I really would like to thank Amnesty for this invitation. For me, this is a crucial topic. Just let me clarify that I have been a presidential commissioner for human rights in 2 governments past, nothing to do with the current government. We're back into a military government with a very ugly face and very bad practices in human rights, to which I have nothing to do. As a matter of fact, we're all suffering persecution again in our own country, in Guatemala. Let me say that I'd like to address this point of the whistleblowers from the human rights perspective. Is what I did. My report to the General Assembly last year in October was on something that in the inter-American system of human rights we called for many years, and is now acknowledged in the UN as well, the right to know the truth, which is the right to know the truth about human rights violations. The right to know the truth was always linked to justice, to the right to justice. And it was part of the concepts of transitional justice that had been sort of being discussed, from the principles to eradicate impunity and to reach justice, to the concept of transitional justice that South Africans had had. But the idea was always linking truth to be the first step to access the justice system. What we actually did in the last 20 years in the inter-American system was, because of the disappearances especially, is to try to say, yes, truth is the first step to justice, absolutely. And secondly, truth should never be a substitute of justice. Those 2 principles are very important. But having said that, truth also has a power of its own. And that is now consolidated. Diane Orlinker from American University was the rapporteur on the updating of the principles against impunity of the UN. And what she did in Principle 4, if I recall correctly, is she said, yes, we have to reach justice in every case, because the state has the obligation to protect and to guarantee the exercise of human rights, and therefore the state also has an obligation to investigate violations when those occur, when those rights are being abused or violated. And therefore a corollary to that is, and the state has an obligation to bring to justice those responsible and to inform the victims and the relatives of what was the result of this investigation. So putting all that in line, Diane says, yes, truth is the first part of the investigation, but what I have discovered, she says, in the past, and this is Principle 4, is that oftentimes a trial is not possible because either there is an amnesty law, which may be legal or illegal, because there is illegal amnesty laws according to the human rights standards, or whether there is a statute of limitation that has passed on criminal legislation of a certain country. But even when there is no prosecution, or even when you don't find the direct culprits to take to trial, or even when they have died because of age, establishing the truth is still an obligation of the state, she says, because truth in itself is very powerful to eradicate impunity. And this is the principle of my report. Truth has the power to eradicate impunity because many of the violations that have occurred were done, or many of the bad deeds, if we want to call them, are done in the assumption that no one will never find out, that no one will never know, whether they be violations of human rights or whether they be bad state policies or bad conduct of states or abuses of states in the name of national security. There's always the assumption that, no one will ever find out. So establishing the truth is always a major priority to eradicating this impunity, this absence of justice. So this was number one. And secondly, the other principle was the principle of access to information, which is part of freedom of expression. As you all remember, we have two dimensions of freedom of expression, is the right to access information and the right to build our own opinion and the right to disseminate ideas and information. And in the right to access information, we also prioritize public information. If everything the state does is in the name of its own population, in a democratic society, we always say the sovereignty lies in the people of a nation, and that sovereignty is delegated to the elected representatives, then they're accountable on everything they do, whether it be financial, which is where we have used the transparency issues and the access to information, but also in terms of policy, and also in terms of mistakes. So the people always have a right to know, all the time, what is being done in their name. This is why we call it democracy. Otherwise, it wouldn't be the government of the people by the people, because it would always be some elite doing some issues in secret. So combining the two elements, the eradication of impunity and the strength of truth to eradicate impunity, but also with the obligation of the state to make all information accessible, with very few exceptions. I do acknowledge that there are exceptions. Diplomatic negotiations can be confidential. The investigative period of a criminal trial, even security operations by security agencies can be confidential at the moment they're being carried out, but not afterwards, not with the results that they had. In my own country, Guatemala, when we signed peace, for instance, in '96, and we had a transition supposedly to democracy, although we now went back to military governments by elections, the Ministry of Defense was saying, yes, we're in democracy, but the budget of the Ministry of Defense must be confidential. And it was an uproar. Everyone said, why? The Ministry of Defense is like any other ministry. And there's corruption in this ministry like in any other ministry. So there's no reason. You can understand an operation itself in practice, an ongoing operation, but you cannot understand a whole ministry keeping their budget confidential. The same way they wanted to keep the presidential expenses confidential. They said that's a security risk. It isn't. The security is in the mismanagement of funds by the president, because then he gets in trouble, but not by secrecy. These are issues, of course, you can keep his schedule secret. Yes, you can keep the route of his transportation. Those are natural issues. But not excused as normally given to not release information. So the second issue I defended in my report is on access to information, which is clearly part of my mandate. There should be a very minimal set of exceptions and highly qualified exceptions, with the principles established by law being for the protection, the necessary element for the protection of other rights, and the proportionality. And finally, the third aspect, and here's where the crucial element came, is that of all the information the state has, the most relevant information that cannot be hidden for any reason at all is the information related to human rights violations. Because then, if we allow any authority or any state institution to keep that secret, we're establishing a ruthless authoritarian regime that will not be accountable on the atrocities and the violations they commit. And this is exactly the right to truth. Normally, the right to truth is used to information, the access of information related to human rights violations. It is the right to know the truth about human rights violations. And what I say in my report, this was a right established for the victims and the relatives. It began with the disappearances, because it was the right of families of the disappeared to keep on investigating permanently the whereabouts of their relatives. But it was then expanded to all violations. any form of violation. Even if there is no, there's a decision by the Inter-American Court, very, very interesting decision. There was a massacre in El Salvador, a massacre in Mozote, which could not be prosecuted because the authors were not alive and there had been already a statute of limitation. And therefore the state of El Salvador was refusing to give the information to the community and the organizations. And the Inter-American Court of Human Rights said it is an obligation of the state to report whether there is a trial or not. And the state had to hand over the information of who gave the orders, how it was planned, and who carried out the massacre in El Mozote. This is very important to guarantee the principle of non-repetition of human rights violations. And I have it in the report. And let me finish then the next step. The next step goes into whistleblowers. What is the next step? If there is a priority of information on that information related to human rights violations, many countries have, even in the law. In Argentina, by the way, the law to access public information says that for information related to human rights violations, there are no exceptions possible, not even on the basis of national security. I think this is important, because then it means that human rights should be the priority of all states, and there should be no reason that would excuse human rights violations. So if that is true, then there's no reason why any public official can deny information. In criminal law, in many countries you have a principle where public officials who see or observe or are witnesses to a crime have the obligation to denounce this crime to the prosecutor general or to the prosecutor's office. And if they don't denounce the crime, they become accomplices. They commit another crime. This is a form of being accomplice to a criminal act by silence. I use the same principle and I say we should apply this to human rights violations. Anyone who comes about the information of human rights violations and does not make it public then becomes an accomplice. So not only should we protect whistleblowers, but I go beyond that and I say every public official has the obligation, the legal obligation on human rights standards to be a whistleblower when it comes into reference to knowledge or information of human rights violations, whether it be in testimony, whether it be in writing, in photograph, in audiovisual, in any form. There's a beautiful example of this. In Argentina, just recently I was at the Ministry of Defense, and now the Ministry of Defense is handled by victims of what were the military dictators, so it's a turnaround in history. And the minister was telling me that there was one officer of the Air Force that looking down through the second level basement, the third level basement they had in one of their garrisons of the Air Force, he discovered an old box and he decided to open it. And lo and behold, he found the files of the junta, the military junta, and all the records they had. And he was saying in other times he would have taken this out and burned it. But he did the right thing. He took it out, preserved it, handed it over to the Minister of Defense for release, and the Minister of Defense published them. And they're public knowledge over there. What is the conclusion of this? Whistleblowers are not only relevant because of the item of news that we carry, from individual acts like that, from the Watergate scandal to the Pentagon Papers to whatever other scandals we have had, because they make issues known to the people. And the right to truth is now not only related to knowing specifically individual events, but it's also the reconstruction of history, it's also mental health, it's also the reestablishment of the social fiber and social network of a society. So whistleblowers are an essential part of that. But specifically, there should never be any legal liability for denouncing information related to human rights violations. And this was the position that Catalina Botero, the rapporteur of the Inter-American System, and myself at the UN took in the public statement we made on the case of Julian Assange and eventually on Snowden as well. There are important moments when people that know that there have been violations committed will denounce this without putting other people in danger. Obviously, this is a precondition. But we felt that that had been fulfilled and that was the condition available. So whistleblowers should be protected as an element of human rights and are necessary for the exercise of the right to truth.
We'll now hear from Avigdor Feldman, a lawyer, also the son of Holocaust survivors and the son of a bookbinder, who, after studying law at Tel Aviv University, went on to be one of the key founders of B'Tselem, the Israeli Information Center for Human Rights in the occupied territories, as well as be involvement in and key involvement in several other of the principal civil rights organizations in Israel. He often takes on criminal cases that bring out aspects of civil rights and other political aspects of the cases, and among other things represented Mordecai Vanunu shortly after he was forcibly brought to Israel in 1986, and continued to represent Vanunu during his incarceration, particularly during the prolonged struggle to get out of solitary confinement.
Thank you. I'm very glad to be here and quite amazed of the large the large number of people who came to here, because if such an evening will take place in Tel Aviv, probably 10 to 15 people would come and listen, because Vanunu is actually a non-issue in the Israeli public and society, which is something which we need to speak. I'm coming here because Mordechai Vanunu was not allowed to come to this conference. We got a letter from the Minister of Interior, who is in charge of this order, which doesn't allow him to leave the country. And he has another restriction. He's not allowed to speak with strangers. He's not allowed to speak with anybody who is not an Israeli citizen. So if he meets somebody at a cafe or he lives in East Jerusalem, he needs to ask him, can I see your identity card, and to be sure that you are not an Israeli, that you are an Israeli. I never heard of such a restriction. I wonder even if North Korea will issue such a restriction not to speak with strangers on any subject, not on nuclear issues, but on any subject. So he's actually isolated in the Israeli society. The Israeli society don't speak with him, and he's not allowed to speak with strangers. So we actually in solitary confinement even after he left the prison. I would like to read one paragraph from the Minister of Interior. This kind of phrases and text we are receiving for the last 10 years. As you said, as it says here, the reason for which I forbade your client departure from the country following the hearing held, these reasons were extensively reviewed. These reasons do not allow to grant the application of your client to leave the country for the purpose specified in your application. In light of the above, there is no restriction or guarantee that your client can deposit. We even suggested to put some guarantee, money or whatever, which will have the power to secure the state of Israel and its residents against the damage that might be incurred as a result of your client's departure from Israel, a damage which your client has expressed more than once his willingness to cause if allowed to leave the country. Your client retained the ability to cause such damage that would be irreversible, using the information which he has, which he was proven in court, is relevant today as well. Let us remember that Mordechai Vanunu worked at the nuclear facility in Dimona more than 30 years ago. And somebody told me that if what was happening 30 years ago is still valid today, there is a lot of doubts about the Israeli security. Vanunu is quite a unique person. He has an ability, really, to sidestep any restrictions which are given upon him. Can I see the second picture, not this one? This is a very famous picture when he was brought to Israel under, nobody told his name. He was able at the police car to show his hand, and he wrote on his hand, I was kidnapped from Italy, and exactly the date he was. the restrictions forced upon Mordechai Vanunu are from the first day that he left prison. Peter mentioned the fact that he was 11 and a half years in solitary confinement. I visited him through this time, and I must say I had deep concerns about his state of mind. He was really paranoidic. He was speaking, he was telling me that the birds are talking with him, that the television which he had in his room are sending messages to him, that the type of food which he gets also gets a message. There was even the prison authorities was concerned, and he was taken out of confinement after 11 and a half years. I don't know why he was in solitary confinement, what damage was when he was able to walk in the prison, to speak with prisoners, to them who really would like to hear from him. I have no doubt that this is a punishment, a revenge of the Israeli authorities against Vanunu. And Vanunu actually broke the most important taboo in Israeli society. A taboo which, strangely enough, everyone knows about it, before Vanunu and after Vanunu. There's not one person who deals with the issue of nuclear weapons in the Middle East that doesn't know that Israel is producing nuclear weapons. It started with France's help, and then was a secret agreement of the United States, which did not impose on Israel the restrictions which it does impose according to the Congress law for any country who holds nuclear weapons and is not party to the non-proliferation of nuclear weapons. Can you see the second picture? Well, this is his car, which he came, and somebody wrote on it, traitor. Remember that Mordechai Vanunu was charged with treason, not with spying, with treason, because he gave Peter Hunam to a newspaper, not to the enemy, information about nuclear weapons, so he was tried as a traitor. Can I see the bomb? Well, here is the bomb. In the nuclear facilities, there is a room, that's what Mordechai told me, that is closed and nobody is allowed to enter it. But if a new prime minister is being elected, they take him very formally and with great ceremony to this specific room, which has a model of the bomb. You see it, this is a model of the bomb made of some of wood, some of some kind of nickel, and this is actually, I would call it the fetish of the Israeli society. The bomb, we have another picture of the bomb, can I see it? And Vanunu, as I said, has a neck to overrule any restrictions, was able to find, another one, was able to find the key to this special, this is again the bomb. He was able to find very easily the key to this secret room. Actually, what motivated Vanunu, he was working night shifts in the nuclear facility, and he was curious. The main characteristic of Vanunu is curiosity. He wants to know. He wants to understand what is happening there. And of course, the people who work in the nuclear facilities were not told that in this place they are producing. He was he was a simple technician. He was not an engineer. He was not part of making the bomb. His job was to push some buttons which helps to create the plutonium which is used for the bomb. So he started moving around in the nuclear facilities. Nobody really checked him. Nobody really asked him what he is doing. There's no security there. And other strange issues, the authorities are so certain that nobody will reveal the nuclear weapons because there is this solidarity, this, I would say, this fetish, this secular God which everyone is worshipping, that they even didn't check Vanunu's background. Vanunu was, before he started working there, he was in the Communist Party. He was a member of the Communist Party for a short time, really, and nobody asked him, nobody cleared him, and he started working there. The bomb in Israel has a very special position. This is the word for it is the ambiguity. Israel will not deny and will not prove that he has nuclear weapons. There is all kind of dogmas and ambiguity. Oh, 1 minute. And ambiguity is actually one of the main issues of Israeli society, and it permits everything. Israel is ambiguous about what is a Jewish state. Nobody really knows what is a Jewish state. Now they want to act a law which will say that Israel is a Jewish law, a Jewish state, what religious, non-religious, what is exactly. Israel doesn't have borders. There is no law which actually says what are the borders of Israel. So this ambiguity, or this skeleton in the closet which Israel keeps, actually permits all aspects of Israeli society, and Vanunu break it. And because he broke it, he has such harsh punishment, and the Israeli Supreme Court ratifies. We were in the Supreme Court about 10 times or 9 times and trying to abolish this restriction. Usually some people in gray suits go into the court without us, explain the court in a few minutes. It just happened a week ago in our petition to let him leave the country. 10 minutes and the court is already knows what's the nuclear weapons, what's the secrets which Vanunu can give. It's really unbelievable. Israel considers itself the most democratic state in the area. Mordechai Vanunu is not a good example of democracy. Thank you.
We'll now switch regions of the world. Kathleen McClellan will speak to us from her position as the National Security and Human Rights Deputy Director for the U.S. Government Accountability Project, a leading whistleblower protection and advocacy organization. And she will, in particular, speak about the support she's given to national security and intelligence community whistleblowers, focusing on the issue of torture, surveillance, excessive secrecy, political discrimination, and the representation that she's given to whistleblowers with the National Security Agency, the Central Intelligence Agency, and other government agencies in the U.S.
Thank you. Thank you to the Frontline Club and Amnesty International for organizing this important event. A little over a year ago, thanks to whistleblower Edward Snowden, The Guardian published the first stories exposing the National Security Agency's surveillance operations. We learned then that the U.S. government had sold us a bill of goods. U.S. government officials told a series of misleading half-truths and outright lies to conceal what has become a U.S. surveillance industrial complex and all of the waste, fraud, abuse, illegality, and loss of valuable intelligence that comes with it. Mr. Snowden's revelations showed us that, contrary to what U.S. intelligence agencies had told us, mass surveillance is not effective at stopping terrorist attacks. Mr. Snowden's revelations showed us that, contrary to what U.S. intelligence agencies had told us, many of NSA's programs are not legal. They are based on fatally flawed, secret interpretations of law and opinions issued by a secret court when a court is even involved at all, which is not in all of the programs. Ironically, given the fear-mongering hysteria from the leaders of the U.S. intelligence community about still unspecified damage to national security from Mr. Snowden's revelations, the biggest leaker of classified information in the United States is the U.S. government. With regularity, senior government officials selectively leak information about U.S. intelligence activities, often using those leaks to cover up even more invasive surveillance programs. That is what makes one individual truth teller so threatening to institutions protected by secrecy and plagued by corruption. And that's why, in response to the understandable global public outrage about NSA's mass surveillance, the NSA chose not to investigate the officials who needlessly and in secret invaded the privacy of hundreds of millions of innocent people. Rather, the intelligence community has spent untold resources investigating and attempting to discredit Edward Snowden. It's a very predictable response for an institution to focus on the messenger rather than the message. It can be an effective distraction to focus the media and public attention on one individual rather than exposing systematic, widespread illegality in a powerful government agency. It's a dynamic we see often at the Government Accountability Project, where the U.S.'s leading whistleblower protection and advocacy organization. And my work at GAP focuses on national security and intelligence community whistleblowers, and for those people, retaliation is as bad as it has ever been. And that's something Edward Snowden witnessed. Mr. Snowden saw the abhorrent treatment and torture of Chelsea Manning, and he saw what happened to NSA whistleblower Thomas Drake, one of our clients at GAP. Mr. Drake went through every internal channel available to U.S. national security whistleblowers when he saw NSA was engaging in illegal surveillance. He was a material witness in 2 9/11 congressional investigations. He went to the Congressional Intelligence Committees and to the Department of Defense Inspector General. The Department of Defense Inspector General did an investigation that substantiated Mr. Drake's claims and those of 4 other whistleblowers, but the report was immediately classified and hidden from the public. Using those internal channels was not only ineffective at attaining accountability for NSA management, there was no accountability, but it made the whistleblowers targets of a federal criminal investigation. The government conducted coordinated armed raids on all of their homes. One whistleblower who went to the Inspector General, Bill Binney, had a gun held to his head as he stepped naked from the shower. All 5 whistleblowers lived under the threat of criminal investigation for years, when finally Drake was charged under the Espionage Act. That's the same law the U.S. government tried to use against Pentagon Papers whistleblower Daniel Ellsberg, and it's the same law they're now trying to use against Edward Snowden. In the Drake case, the prosecutor accused Drake of, quote, endangering troops on the field, end quote. But the case against Drake completely fell apart. It collapsed under the weight of the truth, and the government dropped all the felony charges. Whistleblowers in all corporate and government spheres risk choosing their conscience over their careers, but under the Obama administration, national security and intelligence whistleblowers face choosing their conscience over their very freedom. The Obama administration has prosecuted more people under the Espionage Act for alleged mishandling of classified information than all past presidential administrations combined. The Espionage Act prosecutions are a way of chilling speech. They're a backdoor way of going after journalists. The Obama administration has used these leak investigations to seize Associated Press phone records impacting over 100 journalists. They've fought all the way to the Supreme Court to force one reporter to testify about his source, arguing the entire time that there is no legally protected confidentiality between a reporter and his source. They've used a leak prosecution to accuse another journalist of being a co-conspirator to violate the Espionage Act simply by doing his job. This chilling atmosphere explains why, tragically, a whistleblower had to leave the United States to expose U.S. government abuses. Mr. Snowden has always said he wants to come back to the United States, but he should not have to come back to decades in prison. For now, we are hopeful he can obtain and continue his asylum in Russia and remain safe from U.S. persecution, because right now that's what awaits him in the United States. High-ranking current and former senior officials in the U.S. government have called Snowden a traitor. They've joked about putting him on the kill list. They've said he should be hung from a tree. Meanwhile, Snowden faces charges under the Espionage Act, which is a World War I-era law intended to go after spies, not whistleblowers. And being tried under the Espionage Act would not be a fair and open trial for Mr. Snowden. There is no public interest defense to an Espionage Act charge, no whistleblower defense, no salutary motive defense. Recent experience shows whistleblowers charged under the Espionage Act have to fight their charges blind and with their arms tied. In Drake's case, the government filed a motion to preclude any mention of the word whistleblowing. In another Espionage Act case, that of Central Intelligence Agency whistleblower John Kiriakou, who helped expose the CIA's torture program, the judge ruled that Kiriakou could not tell the jury that he had no intent to harm the United States. Kiriakou ended up pleading to a non-Espionage Act charge and is serving 30 months in prison. Ironically, sadly ironically, if Kiriakou had tortured detainees instead of objecting to torture, he would have immunity. Many of the pretrial proceedings in an Espionage Act case are conducted in secret. Defense attorneys must write their briefs in a government-controlled facility. Even at trial, the government can use secrecy to manipulate the proceedings to its advantage. For example, the silent witness rule has the lawyers, judge, and jury speaking in code, and the public cannot understand what's happening. Or in Drake's case, the government charged Drake with espionage for retaining a document that was marked unclassified. The prosecution argued that even though the document was marked unclassified, the information was really classified, and Drake should have known that the document was marked wrong. Into this chilling atmosphere stepped Edward Snowden, sacrificing his life as he knew it to tell us the truth. And Snowden's revelations have already changed the world. He unchained two branches of the US government, Congress and the courts, that were not functioning as the US Constitution intended. In the years since Snowden's revelations, over 20 bills have been introduced in the US Congress aimed at reforming NSA's surveillance laws. It still remains to be seen if any of those will actually be successful at doing that, but they've been introduced. Widespread bipartisan support in Congress to end bulk collection of Americans' phone records exists in a way that has never happened since 9/11. The first court to examine the bulk collection program found it to be almost Orwellian and likely unconstitutional. An independent federal agency found the bulk records collection program to be illegal. The White House's own hand-picked review panel recommended ending bulk collection. The intelligence agencies are now forced to defend their actions in public, and they're having a lot of trouble. But they've been forced to release an unprecedented amount of information about surveillance activities, including opinions from the secret court that authorizes surveillance. And the UN passed a resolution declaring a worldwide right to privacy. Without Edward Snowden, this conversation would not have happened, much less any of the reform. Without Edward Snowden, all the public would hear would be the government's deceptive spin. That is the value of his whistleblowing, and the reason we need to protect whistleblowers. Democracy is dependent upon an informed citizenry, and because of Snowden, the public, not just in the US, but worldwide, is finally, more than a decade after the NSA used 9/11 as an excuse to violate the privacy of hundreds of millions of innocent people and spy on entire populations of innocent people. More than a decade later, because of Edward Snowden, the public is finally equipped to have an informed debate.
Well, next hear from Nancy Hollander, an internationally recognized criminal defense lawyer. She she's with an Albuquerque, New Mexico law firm, and also has an associate tenancy here with Doughty Street Chambers here in London. She's been devoted in her practice to representing individuals and organizations who are accused of crimes, including those that involve national security issues. And she's been counsel in numerous civil cases as well, including a case involving religious freedom that went to the U.S. Supreme Court. She's served as a consultant to the defense in a high-profile terrorism case in Ireland. She's assisted counsel in other international cases, and she represents 2 prisoners at Guantanamo Bay, among other things. I think I can also say with confidence that she may be the only lawyer I've ever met who has a racing license and is in addition a martial arts expert.
Thank you. I wouldn't say expert, but I work at it. I'm really honored to be here and thank Amnesty International for bringing me. And I'm also honored and humbled and actually excited to be Chelsea Manning's lawyer on appeal. Appeals are never easy, but even at this very early stage of the appeal, and we've just begun this case, and we've just gotten started, we also already know that we have many valid issues, and if justice does prevail, then we will win this case. Chelsea, who's facing a 35-year sentence, has already been punished enough. She spent time in pretrial confinement under horrendous conditions that were completely unnecessary and were totally punitive, and there was no excuse for them. She's also was denied the right to a speedy trial, partly because she was kept in these unlawful pretrial conditions for so long. And fundamental due process of law was denied to her throughout this trial. But one of the big issues that we already know is, of course, as Kathleen already talked about, the Espionage Act. This was an act that should never have been passed in the first place, but was passed during the height of World War I and should have been repealed right after World War I. But even then, it was meant for spies, saboteurs. It was never intended to be a law that would entangle whistleblowers. And yet, it has become really that, just little more than a trap to ensnare anyone who embarrasses the government through their whistleblowing. And that's really how it has become to be used. Chelsea's espionage convictions alone would be enough to appeal on her behalf and really for the benefit of all of us, because the way the court has interpreted the Espionage Act now, it fails to distinguish between providing information to harm the United States and providing information to protect the public's interest. There is no whistleblowing defense under the Espionage Act as it stands today. Unless we reverse this and force the courts to understand and reverse this statute, the stage is set in the U.S. to incriminate any American or anyone who can be charged in the U.S. who reveals wrongdoing to the media. And of course, it can also ensnare journalists. And there's a big fear in the United States about how the Espionage Act will get used, since it has no defense except, and no intent required except the intent to disclose. That's the only intent that's required. Chelsea's is not the only case. We saw a case in federal court, the Kim case. And this is a progression that's been happening, and the progression that we have to stop. At the same time, and at the crux of this, is what is national security? What does that mean? And we've seen an example just recently of how vague it is. And that example was the release of the 5 Afghani men from Guantanamo. We were told, and particularly all of us who work in Guantanamo, that these were part of the group of what we call the forever prisoners. They can never be released. They can't be tried because we don't have any evidence against them. But put that aside, they've been in Guantanamo. Those particular 5 men were among the first to get there. They have very low numbers. That means they spent time in Camp X-Ray, which is just nothing but a giant dog cage. And they've been there since 2002, never charged. And everyone in America was told they can never be released. Why? Because we have to protect national security. And then all of a sudden they get released. And what are we told? Well, it's okay, our national security is protected. So if national security, which is really defined as what's going to harm the U.S. or aid the enemy, that's what it really means, is that vague, what does that mean for someone who's charged under the Espionage Act? And it does include information that's not classified, information that somebody's supposed to know should be classified, information that the government just considers secret, even if it's not classified. But add to that the problem that the government now, the U.S. government, has way over-classified information. So in addition to the fact that you're supposed to know what is classified and what isn't, everything that remotely touches on what the government at one moment or another calls national security does get classified. So the government has another huge advantage in an espionage case, because if something is stamped classified and disclosed, then that becomes a violation of Espionage Act. And again, the government is violating the law. What becomes classified comes out of an executive order from the president, and it lists what the rules are. And it also says what cannot be classified. And it specifically says, every executive order going back as far as when they started, including the recent one, says the government cannot classify information for the purpose of protecting the government from embarrassment. And yet, why is it that we can't know about the torture of individuals in the black sites? Why is it that we're not allowed to know things that we should know? It's because the government would be embarrassed. So the government is breaking the law. The government also is told in the executive order that it cannot classify information it does not control. And yet the government has classified information that it does not control. And so you've got this horrible act to begin with. You've got an act that no longer requires much other than a basic intent, so it's really become what we would call a strict liability crime. And then everything gets classified so that it all lines up in favor of the government. A healthy, free society needs to know, the public needs to know what the government is doing. And if the government continues to hide, then we can't have a free society. Now, I'm not saying, and I agree, there are certain things the government does have to keep secret, but they're minimal, and it always has to be balanced. What is national security has to be balanced against what the public has a need to know, and that balance is what we don't have. There need to be safeguards. The courts need to have permission and the authority to review what's classified and what isn't. And the executive department says the courts have no interest here. If we say it's classified, if we say it's secret, that's the end. And every time a court starts to get into that area, they get shut down. And that's where we are in the U.S. At the same time that the U.S. has overclassified, as Kathleen said, it doesn't prosecute everyone who leaks information. It only prosecutes those who embarrass the government or are low level. You know, Chelsea, this came up recently with Chelsea, and there was this big publicity event that the United States government might move her out of the military prison into a federal prison if she wanted to have to deal with her gender dysphoria issues. Well, that was leaked. That was information that was leaked out. But I don't think I noticed anybody getting prosecuted for leaking that information. And yet, it was about Chelsea, who's doing 35 years for leaking information. This, this draconian Espionage Act has to stop if we're to have freedom of speech in the United States, if the public is to have the right to know. So if for no other reason than that, if that were the only issue on Chelsea's appeal, it would be an important appeal. We have many, many other issues. Just about everything the military has done to Chelsea since the beginning has been unconstitutional, has been a violation of law. There's no denying that this appeal is going to be a long road. And it's real easy for people to forget someone whose case is over. It's not in the headlines every day. It's a long, slow process. But my co-counsel, Vince Ward, and I are committed to this case. We're going to read every page. We're going to research every issue. We're going to fight this case. And, you know, there's one right that Chelsea still has in the United States. And that's the right to have somebody stand, some person stand with her and fight against the power of her government. And it's an awesome power, and it's an awesome power when it's directed against an individual. And that's the fight and the stand that we have to take. I thank you all for coming to this little event, this wonderful venue. On Chelsea's behalf, though, I hope that you will continue to support her throughout this long appeal process, because this will prevent a deeply undemocratic and flawed precedent for the United States. Thank you all very much.
Our last panelist is the Lieutenant Colonel, the Reverend Nicholas Mercer, who was admitted as a solicitor and then joined the Army Legal Service. He served in Northern Ireland, Bosnia and Herzegovina, Cyprus, Germany, and he was also command legal advisor during the Iraq War in 2003. He's lectured on international humanitarian law, and he was named the Liberty Human Rights Lawyer of the Year in 2011. Finally, in what can only be the most interesting of career paths, he was ordained in the Salisbury Diocese and is currently serving as a curate in the parish of St. Mary the Virgin in Dorset.
Thank you very much. Thank you very much for your kind invitation this evening. It does seem like rather a lot of career change. I was first a lawyer, then a priest. It's just I've done different things within that. But I want to talk to you briefly tonight about torture. And I was, just after I left the army, a book dropped through my letterbox called Cruel Britannia. And it was by Ian Cobain, and a letter from Portobello Books, would I review the book? And I felt rather flattered. I'd never been asked to review a book before, and so of course I said yes, and then I set about reading the book. And what this book does is provide the counter-narrative to the British sense of fair play. In other words, you see the black and white films, we all behave decently, we all have patrician accents, and the world was a better place in times gone past. What this book does is expose something behind that. In other words, how the British tortured people at the end of World War II. Generally, we behaved honourably, but we did break from that. Then the torture in the colonial campaigns, the torture in Northern Ireland, and then the end is Iraq and Afghanistan. And I am a footnote in that story. But as well as exposing the torture, and let me just set out the benchmark at the start, it's illegal. It's a breach of international law, it's a war crime, it's a breach of our domestic law. There are no Bravo 20 situations. But there were a whole series of people who have blown the whistle on torture and paid the price, and are still paying the price as we speak. And I just want to bring your attention to that this evening. The first one I came across was a chap called Robert Irvine, who was a police surgeon in Northern Ireland. And he was a competent surgeon, and he noticed that prisoners were suffering injuries during their detention, and the police were saying these injuries were self-inflicted. In other words, they were banging their heads against the wall. Now, let's not be naive, these things do happen. However, experienced surgeons will be able to distinguish the good from the bad, and he started to make complaints about this. He started to meet with the police authorities, and so on and so forth. Amnesty International, after a TV programme, Amnesty got involved and produced a 72-page report which said maltreatment of suspected terrorists has taken place with sufficient frequency to warrant the establishment of a public inquiry. The reward for Irvine was an attempt to discredit, in fact a fairly comprehensive set of articles which appeared about him in the press. He was motivated by malice because he'd suffered a demotion. He was a drunk. He had his judgment affected by domestic problems. He harboured a grudge because the RUC had failed to identify and arrest someone who had allegedly attacked a member of his family. And Roy Mason, the Northern Ireland Secretary at the time, said, such behaviour cannot happen in Northern Ireland. The next year, the UK were found liable in the European Court of Human Rights for inhuman and degrading treatment of prisoners held in custody during Operation Demetrius. So that's one. Ben Griffin is another man I met at a Pax Christi tablet dinner. And this is current, this is live. He was a good, honest, decent soldier. He's tough, he comes from a tough background, he was in the parachute regiment, and he transferred to the SAS. He was so horrified by the treatment of prisoners in Afghanistan, and let me just qualify that this is Iraqi and Afghan prisoners. Iraqis have been moved from Iraq in breach of international law into Afghanistan. You're not allowed to do that under the laws of war, but it's been done. That he decided, I'm not soldiering anymore. Well, normally you're court-martialed. It's a no-brainer. You're under military law, you refuse to soldier, disobeying a lawful command, operational circumstances, you're going to jail. That's the deal we sign up for. Except they didn't court-martial him. His commanding officer said, he was a balanced and honest soldier who possesses the strength and character to genuinely have the courage of his convictions. He was discharged honourably from SAS. Why? because he held the secrets about prisoner mistreatment. Court-martial, it would bring it out. So he then sets up an organisation called Soldiers for Peace, or Veterans for Peace, I think it's what it's called. The Ministry of Defence took out an injunction against him. So there's a soldier in our midst, he lives in London. If he speaks out about the mistreatment, in other words, the torture of prisoners and the rendition, he will go to jail. So that's live as we speak. So we lose this in the bigger picture. So it's obscured by all sorts of other things. And then there's Craig Murray, the British ambassador to Uzbekistan. He went to a human rights conference, perhaps a cautionary tale there, where he had a pot at Uzbekistan. And he basically said, why are we handling torture, evidence produced under torture? It's a breach of international law. It's a breach of human rights norms. Why is the Foreign Office dealing with this? Now, this is quite instructive because whilst he's away on holiday, they start dismantling his department in the British Embassy. And then when he gets back, he's confronted with 18 charges. Nothing to do with speaking out against torture, but they include a whole variety of things, such as hiring pretty young women for the visa department, granting UK visas in exchange for sex. The Foreign Office basically presented him with these charges and gave him a week to resign and told him that discussing the charges would be a violation of the Official Secrets Act. Now, for those of us who've worked in the public sector like me, this is what happens. You get the threat of breaching the Official Secrets Act. You get an internal hearing. We don't have the privilege of employment tribunals. It's done internally with their own rules, and the lawyers who probably draft the charges giving the advice on procedure and so forth. And the other thing it forces you to do is defend a whole series of charges separate and distinct from the issue you've raised in the first place. You're forced onto alternative legal ground by the nature of the allegations. There was a whistleblower recently called Raj Mattu, who's an NHS doctor, and he said what happened was that he whistleblew about the NHS hospital, and then he found himself with a whole series of professional allegations that he had to fight off against the GMC, even to get back onto the original territory. So these are some of the tactics that are used. Secrecy, throwing you onto different charges, internal procedures that you haven't got a hope in hell of winning, and so on and so forth. As I said, I'm just a footnote in this, but this is what happened to me. I was the chief lawyer for the Iraq War, so I was there at the Iraqi border in 2003. A commander has a lawyer by his side. I intervened in the mistreatment of prisoners. I saw them being hooded, saw them in stress positions, and I put in a memo and a complaint. And that story is fairly well documented. We were largely ignored, but in 2003, later that year after we'd left, Baha Musa was beaten to death. And there was a court-martial. This story would probably have never come out, because I actually do believe in secrecy. I believe in secrecy in the military. There are a lot of occasions, if you're preparing for a war, it needs to be secret, period. There are some things I've been working on in the armed forces that need to be secret. I won't break that. What I did was go to court and give evidence. And my evidence unpicked the Ministry of Defence. I told them everything that had happened. There'd been a debate about the 5 techniques. There'd been a debate about prisoner standards. There'd been a debate about the Convention on Human Rights. We'd asked to bring in a judge to have legal oversights. We'd looked at review of prisoner detention and so on and so forth. And all of it had been closed down by the Ministry of Defence. I just gave evidence as a lawyer at a trial. What happened next was as follows. The trial ended on the 17th of March 2007. 2 weeks later, I had my confidential report, which is part of the review process. Most employees suffer it. I was recommended, as usual, for promotion and so on and so forth. I mean, I was a lawyer working and worked pretty hard and assiduously. On the same day, the man whose department I just unpicked in the witness box recommended that I should be deselected for my next post on the grounds of competence. So I was recommended for promotion on the same day that I was deselected. I think I'm the only army officer ever to be promoted and demoted on the same day. It's a remarkable achievement. I do know of one other, but it's slightly different circumstances, and it's to do with courage and bravery. But this is a different scenario. Now, these things happen in careers, and I was leaving the army anyway to join the church, so there's a theological narrative to this at the same time. But being the sort of guy I am, I fought this through the internal procedures for 5 years, eventually taking it to the Queen. That's actually a constitutional nonsense, because Her Majesty just writes noted in the margin. But you're never going to beat the system in the army. So I've then taken it into the civil courts, and one of the documents that I've asked for 7 years, I have recently asked for again, and it's currently before a court as we speak, so I can't say too much. But let me just say that there are all shades and types of whistleblowers. I don't see myself in that category other than a witness who's revealed the shenanigans of government during a war. But I'll finish on this note. I got a phone call in the middle of the Baha Musa inquiry, and I met an officer who said, look, I've got information about the Ministry of Defence, and I'm so petrified of giving that information that I want you to do it for me, because I don't want what happened to you to happen to me. Anyhow, thank you.
In the interest of allowing enough time for questions, I won't attempt to summarize. I'll merely highlight a couple of issues that have come out. Obviously, the tremendous imperative for secrecy we're seeing in country after country. We're seeing also the use of as many techniques as possible. Manipulation, shenanigans was a word I heard, in terms of efforts to try to silence those who speak out, whether that's through procedural means, through misdirection, through things like the Official Secrets Act or espionage charges or the like. And on the other hand, of course, we have the human rights that are at stake, including the right to truth, which we've just heard about. It's, of course, a bit ironic that all this is going on at the same time that some of the whistleblowing that we're hearing about has to do with the government's efforts to know more information about people, to get more information, to engage in mass surveillance. So without getting too far into that, I think that it is worth noting that it does appear that some states want to have it both ways. They want their cake in terms of secrecy, but they want to eat it too. That is, we don't get any. Let's open it up for questions. We'll take 3 or 4 at a time. And if it is to a specific panelist, then please say so. But otherwise, we'll just have people on the panel respond. I see one up in the front.
Can I ask 2 short ones?
Very short.
Peter came to us 28 years ago, and I've waited 28 years to hear you talking about this, Salvador. I wanted to ask you about the Supreme Court. When I met Aharon Barak here, I had 10 minutes alone with him, and I asked him about, for example, the 2002 petition on extrajudicial executions, which is Israel sanctions. And he said that the government had the right to take it on and off the docket at will and had done it numerous times. Can a Supreme Court that allows a government to take things on and off call itself a Supreme Court? And I was the only human rights person outside the prison, and this is very, very important for you, I think. Ken Roth would not handle it because there was a security oath involved. Mordecai had taken a secrecy oath. And I mean, I think the question you are bringing up about how governments feel they have the right to do this comes from the nuclear security screen. I mean, it allowed the Japanese government to cover up at Fukushima. The IAEA has signatory arrangements that governments are actually, they're not only accountable to themselves and to their electorate, but they're accountable to the IAEA. And so when the IAEA says they can't talk because they're bound by the IAEA security procedures, this thing has crept in and taken over all the military. So there's this absolute right that everything is absolutely secret. I mean, so, you know, nuclear weapons aren't used, but they're secret all the time. I mean, it's not just a question of invading a country. So, I mean, I've proposed to Ken Roth and to Amnesty that they adopt an in-principle opposition to all secrets, which I think is reflecting what you're saying. But when it comes to the secrecy oath, there's a real problem. And I wonder if you're going to be able to address this, because if you adopt such a thing, there are people who will say there are things that have to be secret, and in nuclear weapons, that isn't the case. Everything is secret.
So we have a couple more hands. We'll take a few more questions, and the panelists will have to remember the key points on which to respond. I see one here. Go.
I have two quite quick questions. One is around sort of international law mechanisms, and could a whistleblower be classified as a human rights defender and then have access to the mechanisms that sit within that framework? Because it seems a lot of times whistleblowing is about the defence of human rights. So legally, where is the crossover there, and is there potential for specific protections around whistleblowing that would connect to that framework? I don't know who would wish to answer that. Then my other question was, is Amnesty taking on Chelsea Manning's case as an individual at risk case file to do long-term campaigning?
Follow up on what you say. Yes, my name is Andrea, and I am from Wandsworth local, Amnesty International local group. And the reason that I joined the Amnesty local group is because last year, especially in winter, this summer, at this time of the year, I was attending a lot of protests and vigils and fundraising events that grassroots groups like Veteran for Peace or the Catholic Worker were organizing to support Chelsea Manning. In those events, protests, the fundraising events, we never see Amnesty International campaigners or Amnesty International banners or Amnesty International. I didn't hear that it was supporting local groups to organize fundraising events or providing to your local groups materials to raise awareness about those issues. So my question is, why, having so much capacity, Amnesty International have done so little about Chelsea Manning?
I did see one more. If there is one, we will take one more. And if not, one in the back. And then we'll come to you in the second round.
Great. Hi, I'm Rafael with the Associated Press. I wonder if you've ever come across a situation where you think it's possible that there's a situation where somebody masquerading under the title of a whistleblower actually decides to put information which is genuinely damaging in the public domain. Have you ever encountered such a situation? Could such a situation exist? And if it could, even theoretically, how would you propose dealing with it?
Shall we start with you on the human rights questions?
Yes. Very quickly on two or three of the questions. Can whistleblowers be considered human rights defenders? The answer is yes. They're actually making a huge sacrifice to bring out the truth of human rights violations. And this is what human rights defenders do, denounce human rights violations. So my answer would be yes, and they need all the legal advice and the legal accompaniment, and this is the one right that cannot be taken from them, is the fact that they have a right to be defended by legal counsel. And I think this we should uphold all the time and consistently look at that. In the question on whether there can be a false whistleblower, yes. I mean, obviously, there are moments when people dishonestly can present false information, or maybe even honestly can do it and give information that puts others in danger. Here's where human rights organizations have to be very careful. I think the case of WikiLeaks was very important because it was very clear that WikiLeaks requested the support of 5 big newspapers to go through the information and help sift through it to see that it didn't put anyone in danger. Because it is important to denounce human rights. It is important to point out to the culprits of human rights, like in the most gross violations. But it's also important in laying out this information not to put anyone else at risk. And I think this is a technical matter, and it can be done. That mistakes may be done in a moment, yes, and I think we have to make a major effort, technical, to correct it. And on the question of whether all nuclear information should be open and not secret, I don't qualify the secrecy of an information on the basis of the topic, except on the case of human rights violations. For me, what should never be secret at all, as a principle, is information related to human rights violations that have occurred or that may occur. Yes, if we know of a weapon, whether it be mustard gas or whether it be a nuclear weapon that is going to be used, I think it is reasonable and relevant that that can be made public to stop this from happening, as well as information that has been done, events that have occurred in the past. I would not say in terms of other items, like I do agree with our priest here that some information by necessity has to be secret in the state. I don't think that all information has to be public. Like I mentioned before, there are some key examples of limitations, national security operations or diplomatic negotiations. Some issues, obviously, of the state or the schedule of the prime minister or the president or head of state. Some issues are naturally confidential. But that doesn't apply for me to human rights violations. And where I made the point is that human rights violations should not have secrecy. And this is where we defend the whistleblowers. And maybe one last comment, although that didn't come in a question. My other report was on privacy and freedom of expression. The one issue that I made clear, now that you mentioned it, and I think is very relevant, is that privacy and freedom of expression are two very different rights and two different articles of the ICCPR, but go hand in hand. And we cannot exercise freedom of expression, and this is valid for everyone in any society, if we don't have a guarantee of privacy. So a guarantee of privacy is important for journalists, as you were mentioning, because there is a protection of sources, there is a protection even of the materials of investigation. But they're relevant for everyone else. I mean, we will not be able to speak freely if we don't believe we can keep our messages to ourselves. Some messages will be public because we want them public. Some messages will be private, or some messages will be in a closed group. But that will depend to the speaker, to the messenger. And I think this is important in a democratic society. So we cannot, because we defend the universality of rights, and all rights are equal and interdependent, we cannot say that in national security we should condemn torture or we should condemn arbitrary detention, but maybe privacy is a lesser right that we can violate, which is, I think, what they're trying to make public opinion feel. No, I think we have to, in any democratic society, we must uphold all rights for the sake of defending democracy as well.
Sure, I'd like to address your question about the people that might masquerade as whistleblowers. It's not something I've encountered, and there's two really big reasons. First of all, it's not really a label people tend to seek out. The government likes to paint people as these, wannabe celebrities, but all of our clients are the exact opposite. And a lot of people who become whistleblowers aren't saying, I'm going to blow this thing wide open. They're simply doing their jobs or testifying or bringing something just morally repugnant to the attention of the authorities. And in the good faith that their organization, their institution that they've worked for will do the right thing. And then when they're retaliated against, then they realize, oh, I have become a whistleblower. And your question also draws on a very, very important distinction that we sort of say between leaks and whistleblowing. And there are leaks of information. For example, revealing Valerie Plame's name, the covert CIA operative, in order to punish her husband for questioning the Bush administration's position on the war. That would be a leak. That's not whistleblowing. And whistleblowing has a very clear legal definition in U.S. law. And it's when someone makes a disclosure that they reasonably believe evidences waste, fraud, abuse, illegality, or a danger to health and public safety. So all you really need to do to determine if someone's a whistleblower, masquerading as a whistleblower, is look at the disclosure. And it's in the substance of the disclosure. And the government doesn't really like that. Because what the government wants to do is look at the person and question the person and say all of the things that Nicholas was describing. That's what the government wants, and that's what they want you to do. They want you to be preoccupied with Chelsea Manning's personality and her background, and they want you to look at Edward Snowden, the fact that he never graduated high school. That's where they want your focus. Because if you turn the focus on them, you'll discover that they've been lying. And you'll discover that they've been breaking the law and doing it in a systematic way and deceiving the public in a systematic way. And that's, that's not something that they necessarily want to have to explain.
Well, as a journalist, I'd just like to make the point that there are professional people who try to masquerade as whistleblowers, and they actually do it for money. There was a guy called Joe Flynn. Some of you journalists may have come across him, otherwise known as Barry Gray, who actually hoodwinked countless newspapers and quite a lot of foreign embassies, selling them fake information. And they also tried to do the same thing over the Vanunu story. And fortunately, I got involved in it, and we turned the tables on him and exposed him instead. But it raises this issue that when you have someone come to you as a whistleblower, you do have to understand where they're coming from. you do have to understand a little bit about their motives. It may not mean, just because their motives are mixed, that you're not going to use the information. But you do have to check this out. You have to understand, is it accurate? And it's very interesting, in the case of Mordecai Vanunu, he had lots of information, but he didn't know what it meant. Because as Avigdor said earlier, he was a technician. He had lots of knowledge, because he had a very good memory of the processes that he was working on, but he couldn't explain them. And so our job was to try and pull all that together and check out whether or not it made sense, whether in fact it could have made plutonium, which was one of his jobs. So you need a lot of experience to deal with whistleblowers, and there are these pitfalls. Thank you.
I just wanted to answer the question about Amnesty and Chelsea. Amnesty International brought me here. That's one thing they're doing for Chelsea, and there is a case file that I've been working on with Amnesty that they came to me and asked if they could develop a case file. Chelsea wrote something to go into the supporters, and actually, if any of you saw the New York Times today, there's a long letter from Chelsea that I hope that everyone will read. It's in the New York Times and in the International New York Times about the fog of war. I forget exactly what she's called it, but it's about embedded journalists. And but I'm really pleased to say that Amnesty is finally stepping up to the plate for Chelsea. And if you get the information from Amnesty on a regular basis, you will see that case file. I hope sooner rather than later.
Yeah, the question was raised whether nuclear weapons should be kept secret. We must understand that the nuclear issue is a non-issue in Israel. It's not in the election, it's not in the public debate. So there is such a thing as nuclear weapon which affects every decision which the Israeli government is doing, the territories, the relations with other countries. Everything is secret. Secret also, what are they doing with the waste of nuclear weapons? Nobody knows anything about it. The nuclear facility is quite an old one. It was built in '65 or something like this. Is it okay? Is it still holding? And there were cases which were leaked of people who suffered from cancer by being exposed to nuclear material. So our defense in the Mordechai Vanunu case, which was not successful, was that it could not be kept secret from the people. You cannot tell the people we have no nuclear weapons. You can just avoid the issue that censorship in Israel strikes down any mention of nuclear weapons if anybody writes anything about it. And Vanunu said, and this is another motive, he said, I could not help seeing Israel government lies to the people, telling the people we don't have nuclear weapons, and we have nuclear weapons. This is also Peter knows that this was the main motivation. Mordechai Vanunu is not an anti-nuclear activist. He became afterwards, but he is somebody who, strangely enough, looks for the truth. And the fact that he looks for the truth was the most harmful thing which happened to him, because he suffered, because, as I wrote in the letter from the Minister of Defense of Interior, Mordechai Vanunu said, if I would be going out of Israel, I will go to the United Nations. I don't have secrets, and it's very strange idea that after Peter and Dr. Barnaby just milked everything from him, that he still has any secret. But he said, I will go to United Nations, I will go to everybody, I will go to the United States and tell them. If you wouldn't say it, if you would say, I'll be quiet. I represented another spy, Marcus Klingberg, who was really a spy. He was the second in the Biological Institute, which deals with you know what. And he was a communist, and he gave secrets to the Russians. Classic spy. But he said, after he was released from prison, I'm going to keep quiet. I'm not going to talk about it. As they believed him. And he's now living in Paris and is quite okay. He's nearly 90. I was at his 90 was it, birthday a few months ago. He tells me that he intends to stay alive after all the people who prosecuted him will die. then he is going to die. But Vanunu doesn't say it. I give you one example. His whole trial, of course, was in closed doors. It was in secret. One day, I asked for the court. There was some. I brought to the court Abba Ibn, Shimon Peres, to speak about the fact that nuclear weapons is being discussed by 5 people. Only 5 people are in the secret of nuclear weapons. So I brought them to court really to support my argument that it should be public knowledge. So I said, let's open the doors now. No secrets are going to be discussed, only the political side of the nuclear weapons. So the court asked for the Chai Vanunu, if we will open the doors, you promise to be silent and not to... He said, no, I don't promise anything. He said, maybe I'll keep silent, but I don't make any promises. This is the type of Vanunu. And just imagine, I don't know how many people were involved in the nuclear facilities for the last 50 years, I think, thousands or many thousands. Nobody said anything about it, only Mordechai Vanunu. And he's actually, the Israeli public sphere avoids him. Just now, a month ago, published a book, 500 pages, of somebody who is really an expert on nuclear, Shlomo Aronson, his name. And the book says nuclear weapons in the Middle East from 1948 to 2012. Not one mention of Vanunu, nothing. You can find some Russians, some obscure persons in the index. I looked at the index, nothing, none being Vanunu, and of course nothing refers to what Vanunu actually revealed. So the society punished Vanunu, not the government, not the society doesn't what. When there was an article in Haaretz about this conference, I gave an interview about the conference. You know, it was also in the internet, and the talkbacks, half of the talkbacks, about 30 people said he should be hanged. Vanunu, don't let him go to London. Hang him because he is a traitor. This is the public opinion in Israel.
Yeah, I want to mention the culture of secrecy. Because it's a great information game as well. How do you find out who's got what and where? And even at the lowest level, if you're an ordinary Joe like myself, trying to get information out of the government, I've spent 7 years trying to get a document out of the government's hands, and I'm still doing it. Even though the government want to use the document against you, they won't actually give it to you. You have to go to court to get it. And there's a sort of invading, pervasive culture of secrecy that's beginning to cover our legal processes. If you think, for instance, the Justice and Security Act, which is a classic, so it's passed in 2013. So when people start making claims about torture and rendition in Guantanamo and bring a claim against the state, the first instinct of the government is to pay them off. What do you want? $1 million? $2 million? You can't discuss it. They'll get rid of you that way. That was the old way with the IRA as well. They get fed up with that game, so they then pass the Justice and Security Act, which means now that if you make a claim, civil claim for damages, you can't see the evidence that's used against you, you can't have your own counsel, you can't cross-examine on the evidence that's used against you, and you can't see some of the reasons for the judgment. In other words, you're completely neutered legally. So, I mean, you've basically got your hands tied behind your back. And that really will, I think, put a stop to most of these claims going against it. So you can't seek civil redress. Actually, civil redress actually is a human right and a right under the UN Convention Against Torture, but because it's been thrown into secrecy. But actually, most people don't get it. The justice and security debate animated a handful of lawyers. The vast majority of the public don't get that. if you think you've been kept under surveillance, you can't just go to court and take a civil action for breach of your privacy. You have to go to an IPT. It's in secret. You don't perhaps even know that the case has been heard. So again, the government's using secrecy to mask what they're doing and to deny you a legal remedy which you're entitled to. Again, another human right norm. If we get out of the Human Rights Act, we're really hampered, and the circle is complete. So it's very... We talked earlier about journalism racing after stories about people's personal lives, which is just what the government want you to do. They want you to take your eye off the issue and go after Snowden's girlfriend or whatever he did in the Coast Guard or whatever it happens to be, and the press go whelping off after that. Actually keep your eye on the issue, but at the same time there's this masking of the issue through secrecy. We've just seen the first attempt to have a full criminal trial in secrecy. One of the charges was the guy had got a false passport. Well, since when did that have to be in secret? And it just creeps up, creeps up, creeps up. So in this whole whistleblowing saga, there's an increased response of government to cover up what they've got. And there are other small things. Try going for a Freedom of Information Act, and they'll tie you up in jargon and court cases all the way up to the top. A lot of this stuff is kept in privileged material, so they'll use legal professional privilege, or they'll use medical privilege. And you fight, 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 fight for it. And it's all part of this invidious creeping culture to protect the state from exposing its embarrassing secrets. And I just wanted to mention that one. Thank you.
I rashly promised a second round, and I'm afraid that we are in fact out of time. And obviously, there's much.
Just a sentence.
Yes.
Okay. Somebody with a high position in the security establishment, but didn't deal with nuclear, wrote a book which was banned by the censorship. It was a docu-fiction about a person who was working in this kind of establishment, and he said actually that the only secret which Vanunu may have is that Israel does not have nuclear weapons.
That is an excellent note to end on. Again, we're very, very grateful for such perspectives from such accomplished panelists. In the back, there are some, in addition to drinks, which are very nice, there's some information from Amnesty about some of the cases that we've been focusing on that have been profiled up here, including, of course, Edward Snowden, including Chelsea Manning's case, and including a petition on Vanunu as well. So we would ask you to please pick that up and consider signing on to it. You will doubtless have had additional questions. I suggest you nab one of us as we try to make our way out. Thank you again.
I'm not sure whether I'm not going to have to go fairly quickly. We could take you for lunch on Thursday.